Hi guys, welcome to Law Wednesday. Today's session we will be discussing about scope of copyright in India. This is your law mentor Paridhi Tulsian. Let's start to understand what is copyright. When we talk about copyright, it is a form of intellectual property. Intellectual property rights in our country has been developing since the independence. Now here we talk about the protection granted under the Indian laws to the creators of the original work. Now the original work over here will include all the literary work, all the computer-based work, all the artistic work and other musical, drama and other works which the owner can say that I was the inceptor of this work. Now when we talk about copyright in general, it is about that my work cannot be copied or cannot be used by somebody else unless I have given the right for it. How will I gain copyright over it? The copyright protection works on registration. Let's talk about what is the registration of the copyright. Now, the registration of copyright protects the ownership of the work from an unnecessary dispute. In the event of probable copyright infringement dispute, certificate of registration of copyright and the register of copyright containing particular of registered copyright are considered as admissible evidence in the court of law. If there is a dispute between two parties that who has taken the work or who is the author of the work or who is the owner of the work will be solved by the Copyright Act and under the registration process. They serve a prima facie evidence with reference to dispute relating to ownership of copyright. Now, I have used two words over here, that is ownership and the authorship. Okay. Now, when we talk about ownership and authorship, they can be similar as well as different. So, overall, when we talk about the scope and extent of copyright registration, there are two kinds of works. One is published, one is unpublished. They both are subject to registration. There exists a set procedure for registration of a work under the copyright rules of 1958, which has been suitably amended from time to time, and registration is provided for both kind of work, that is published and unpublished. Now, copyright in works published before 21st January 1958 in the Indian Copyright Act of 1914. That is, before the Copyright Act of 1957 came into force, also can be registered, provided the work still enjoys a particular set of copyright. All kind of literary and artistic work can be subject to copyright, and also one may also file a copyright application for his or her website or any other computer program. Overall, the scope of copyright is any work or any idea which is available in a physical or a tangible form. Now, let's move to the process as we discussed. Filing of an application along with the fee, and there is issue of a diary number which is done. Now, 30 days mandatory waiting for objections. Now, if you have gone for any registration where you want to say that this poem or this particular set of work is mine and I would like to go for registration, there are two options for this. There will be set of people who will file an objection. There will be no objection. Let's see what happens when it comes to no objection. When there is no objection at all, the scrutinization is done by the examiner. Once he does that, there is either a discrepancy or not a discrepancy. Let's assume there is no discrepancy over here. Here, it will clearly go for the registration approved, and 99% it will go for the approval. Once it is approved, sending extracts from the registrar to the application and it will become a registered copyright. But in the scenario where there is an objection filed, and in the case of objection filed, a letter is sent to both the parties. Now, a reply is expected from both the parties and a hearing by the registrar of copyrights is done. Now, here also, if the application is accepted, it will go to the process of application accepted. Again, no objections will be there. And if at all the application is rejected, then it goes to the registration approval where the deputy registrar will send a no. Once a no has been sent, the application registered will be sent for rejection letter to the applicant and it will be rejected. Obviously, there will be reasons stated and also a reply from the applicant will be there to understand why or what was the reason of such rejection or what changes can be put so that it becomes to the subject of copyright. The question comes, who is an author and who is an owner under the copyright? Now, author and the owner, as I said, can be one person as well as two different people. The author is the person who creates the work. The owner may be a different person or an entity. An owner is a person who has bought the rights over the work from the author. Now, if you see, they can be same person, but let's see how they are different. Let's say I have made a poem and I would like to get it published. Now, I have sold the poem to a publication house and I'm giving the right to the owner of the publication house to use my poem in a certain way. The author may be commissioned by the owner or for some remuneration. The person commissioning the work is the owner of the copyright unless there is an agreement to the contrary. It is not necessary there will be a commission. It can be any other kind of remuneration or any other entity can provide any rights over to the author. Now, the owner hires the services of the author to create the work. In such case, the author has a moral right over his work. Whenever we see a song on a YouTube, when it comes live, we see in the description, there is a different lyricist, the person who has written the lyrics, the person who has composed, and who is the producer. Let's say the producer hired the lyricist, hired the person who is singing or whoever is composing, still they will have a moral right over the song. They will get the recognition. Maybe when the copyright infringement will come, the producer will come forward and fight the dispute. Now, the author has a right to be identified as to be the author and the object in case of his work is mutilated, distorted, or modified without his consent. Now you see so many remixes which happens. All these remixes are subject to copyright. Generally, we get the rights from the author or the producer, which is the owner of the product, and then we are allowed to distort or make some modification in that song. All the remake of the movies also require the permission from the author or the owner of the original work. Now here, if there is any modification without his consent and prohibits the owner of the copyright from doing any act that would be to the detriment of the honor or reputation of the author, he can do so. This is known as the moral right as laid under the section 57 of the Author Special Right of the Copyright Act of 1957. They are generally non-transferable. An author can seek damages or restraining orders even after the author has sold the rights of his work. So here the author gets some of the first preferences. Now moving ahead from here, we understand there is one more person in this who is a performer. Maybe I am performing a song which is sung or written or even composed by somebody else. Under the Copyright Act of 1957, which grants a right to performers who may be a singer, an actor, a musician, a dancer, a magician, person delivering a lecture, or any such person giving a performance. Section 38 and 39 of the Copyright Act lay out the rights of the performers. It gives the right of the performers against recording and exhibiting their performance without their consent. The owner of the place exhibiting such recording is also liable to be charged as an infringer. It shall not apply to a rebroadcast of a consented broadcast. So if there is a movie which is already bought by a particular channel, if they rebroadcast that movie, that is not the subject to infringement. But if we have got a right to perform it once and then if we perform it twice, it can be a subject to copyright infringement. Performer has a right to claim damages in case of distortion, mutilation, or any modification of his performance without his consent as well, that may be prejudice to his reputation or honor. For an example, singer Neha Bhasin always claimed her name to be displayed as a singer and not as a backup singer, where it was proved her song was recorded and later exploited without her consent. So there have been a lot of artists who claim such rights on their work, and also with the help of the owner, they also exercise their moral rights. So let's discuss the scope of copyright in India. Under Section 13 of the Copyright Act of 1957, there is an express provision that lays down the scope of copyright in India. Each category of work that has received the attention of the statute have been detailed separately in the different provisions of the Act, thereby making room for exclusive rights that have been associated with each of the provisions. Some of the provisions are mentioned under Section 14, 37, 38A, which are about the significant provisions and added to the concept of laying down established rights for the owner of such copyright. If we move ahead and discuss about Section 16 as well, that states that no copyright shall be in subsistence on work other than those which have been provided under the Copyright Act of 1957. Here, in simple terms, it was stated that copyright is a creation of a statute. It was also stated in the case of Akute Internet Services Private Limited versus Star India Private Limited, where the concept of hot news doctrine was introduced, and the court had also interpreted who was responsible for filing a suit, thereby preventing others from publishing or sharing a match information. In this case, it was said that the claim for an unjust and unfair competition cannot be granted. If we move to the recent developments which happened in the year 2021, on 30th March 2021, the Copyright Amendment Rule 2021 was brought into effect with the primary objective bringing the existing rule in parity with other relevant legislations and ensuring accountability and transparency. Moreover, the amendment of copyright rule aimed at facilitating smoother functioning by adopting electronic means as a primary mode of communication and working in the Copyright Office. Since after the pandemic, it became easier for everybody to use internet and computer-based service, this change was made. The amendments have incorporated a new provision of publication of a copyright journal, which is available at the official website of Copyright Office. The time limit for the Registrar of Copyright to either accept or reject an application for registration of the Copyright Society have been extended from 60 days to 180 days for comprehensive examination. As per the new amendment, an applicant does not have to submit the entire source and object code for the registration of a software. The present requirement is the submission of the first 10 and last 10 pages of source code or the entire source code if less than 20 pages, with no blocked out or redacted portion. So if we conclude today's session, it talks about copyright being a bundle of rights, which can be recognized as one of the foremost form of intellectual property rights, and this right in the form of expression is used in our country since 1957 under the Copyrights Act of 1957. Thank you so much. Please subscribe to our channel for more informative videos.